to allow the accused both to enter and participate in the funeral. That's clear from the record, Your Worship. I can give you the references. So we respectfully submit, Your Worship, that she's had 2 previous opportunities, now the 3rd time. There is clear prejudice, which should guide this court, Your Worship, in the exercise of its discretion. And we ask that the application for the postponement be refused, Your Worship. Your Worship, the 2 provisions that deal with this are Section 342A and Section 168 of the Criminal Procedure Act, which give this court the discretion. We ask Your Worship to exercise that discretion judicially and to find that there is prejudice and that the state's case ought to be closed and that they ought not to be given a further opportunity to call this general, because it's, with respect, extremely prejudicial to the accused to keep on postponing this matter in the manner in which it has been postponed. For a witness who attends consultations, nothing is expressed about her state of health or anything, and then doesn't come to court the next day. It's unfair to the accused. We need to make progress, Your Worship. Your Worship will know that this matter relates back to 2018, Your Worship. It's unfair to keep this matter on the roll for very much longer, and I would respectfully request, Your Worship, to close this, to refuse the first stage would be to refuse the postponement, Your Worship. We're dealing with an incident that took place on the 14th of April 2018, Your Worship, some 4 years ago. It's unfair to keep a simple assault common case pending for 4 years after the event and still not being finalized because some witness attends consultations but doesn't come to court on the next occasion, being the very next day. It seems unreasonable, with respect, Your Worship, to grant any further indulgences. Thank you, Your Worship.
Thank you.
May I just address on one issue, Your Worship, where my colleague said that General Zulu gave permission for the vehicle, Your Worship. I do not agree with that, Your Worship. I just want to place on record. Your Worship, I am in agreement with my colleague, Your Worship, that she was in a position, a senior position, Your Worship, and she will be able to give more light, Your Worship, and will be able to shed more light on the situation at that day as well, Your Worship, as she was the senior of the complainant disposition, Your Worship. However, Your Worship, I will just leave that, Your Worship, in the hands of the court, Your Worship, and I believe it is in the interest of justice, Your Worship, so that we have all the evidence before the court. This is an assault case, Your Worship. This matter has been on the roll since 2019, Your Worship, and not the incident happened in 2018, Your Worship. The matter was only placed on the roll in 2019, Your Worship. However, Your Worship, the state will just inform the court that I will leave it in the hands of the court, but it is in the interest of justice that the court has all the evidence before the court, Your Worship. Please sit there.
At this stage, the court just wants to address the issue concerning General Zulu with regards to giving permission for the vehicle to enter. Mr. Hodes as well as Ms. Hart must take into account General Zulu have not testified, nor has a statement been placed before the court. Is a form of evidence for the court to consider. So that evidence, whether she gave permission, falls short to the court in this regard. There is no such assessment that needs to be made by the court, and Mr. Hodes as well as Ms. Hart very well know that they cannot testify in this regard for the court then to say General Zulu did or did not give. So that will not be taken into account for purposes of the ruling. What the court has to rule on today will be with regards to grant the state of postponement SC or deny the state postponement SC. Is there anything else with regards to the defense in the state which the court should take into account?
Not on my side, Your Worship.
Okay, then the court will just have a short adjournment for purposes of considering the judgment. Court will be ready in half an hour. Matter was then down to 10:15. Court adjourned.
Julius?
Okay. Okay, now I'll. It says what? No, we need the first name. Okay, now I'll Google it. That's fine.
You won't find it.
I won't find it stuff. Thank you.
2019, the appearances at the resumption is as before. Court has then been approached with an application by the state for postponement again with regards to General Zulu, the witness which is not before court. Now, for these purposes, previously on the last postponement, the court have granted a postponement for General Zulu to be present today at court. It has been agreed by the parties that the date for postponement would be today. With regards to the application previously, the court have received Annexure A1, which was a copy of a medical note, which the court have received the original today. In this medical note, it indicates that the witness is suffering from a medical condition. She was ill from the 6th of April 2022 up until the 8th of April 2022. Today, the matter was set down for purposes of further evidence. It has been indicated in the state's application that the state have consulted with the witness on the 5th of May 2022, and the state was placed under the impression that the witness will be here today to give evidence in this matter. So the matter by all means should have continued without any delays. It is also to say that if the matter cannot proceed, then a delay is being caused. The court has to then assess whether this delay is unreasonable in this regard. Court have then received Annexure 2A, and as a fact which is then before the court is that it is indicated that Ms. Zulu was examined on the 5th of May 2022, and according to the knowledge of the doctor, was informed she was unfit for work, school from the 4th of May 2022 up and including the 5th of May 2022. The date that she needs to return to work or school in this regard would be the 8th of May 2022. And it has been indicated that the nature for the condition is again a medical condition in this regard. Now, when the court have to look at fairness, fairness cannot be reconciled with unreasonable delay. It is not possible to reconcile it with the fact that an accused avoid their just desert. The emphasis is the essential problem with which one is here concerned. It is not only the accused who has an interest in the beginning and the conclusion of the case. In this regard then as well, where the court was then addressed with regards to the evidence of General Zulu, it may then favor your case as well as the state case. The court have already indicated that that evidence has not been placed before the court, so the court cannot determine in whose favor that evidence will be in this regard. Now, in assessing whether the delay is unreasonable, it will have to be in terms of Section 342A of Act 51 of 1977. Mr. Houder's referral to the court of a further postponement in this regard would be unreasonable, and the delay would cause prejudice to the accused. The court also take into account the address which was placed before the court by Mr. Houders on the previous occasion. So in terms of Section 342A of Act 51 of 1977, the court may take the following factors into consideration: the duration of the delay in this regard. Now, I have also been addressed with regards to the duration of the delay. I have been informed previously as well as today with regards to the delay itself, where Mr. Houders has indicated that the delay started already in 2018 and that it's a mere assault common case and that the court should have dealt with it swiftly in this regard. The court is in agreement. It is an assault common case and it has to be dealt swiftly as possible. But all cases has been acknowledged by Mr. Houders as well that if there is a charge in the interest of justice, the charge should begin and there should be a conclusion. Fairness should be determined in the eyes of the accused as well as in the eyes of society in this regard. So the charge sheet indicates that the offense was committed on the 14th of April 2018 in this regard. The accused's first appearance for the matter was on the 20th of April 2019. With regards to the postponements, on the 20th of November 2019, there was an agreement for the postponement between the parties for representations, and the case was remanded to the 10th of March 2020 in this regard. Further representations was also conducted. The matter appeared before the court on the 23rd of June 2020. The accused was absent in this regard, and therefore the case was postponed for the 31st day of August 2020, and the case was on the roll for purposes of trial, date to be arranged. And here there's another problem which have occurred, which is the very same problem which the court also sits with today. It is the manner in how this trial is being conducted as well. The original charge sheet went missing also on the 31st of August 2020. Misplacing of this charge sheet, so it is then also indicative of how this matter is being handled in this regard. The matter was then postponed, and subsequently it was on the roll for 14th September 2020, and thereafter the 13th of October 2020. Now, this is an important date, the 13th of October 2020, which the trial had to commence in this regard. In this regard, the media have then brought an application to record the proceedings and as well broadcast the proceedings. That have caused then another delay, whereby the court have then granted the media the application, and the case was postponed for 28th of August 2020. On the 29th of October 2020, the matter have then first started with trial itself, and it was postponed for further evidence. So if one looks at this date of the 29th of October 2020, and the matter was enrolled in 2019. So there's already a considerable period of time which was wasted for an assault matter, which could have been dealt with swiftly, as been indicated by the defense as well as the state. But so far, the postponements was in relation to an agreement between the defense and the state with regards to the waste from 2019 to 2020 in this regard. The matter was then subsequently placed on the roll on the 9th of March 2021 for further evidence in this regard. Due to the fact that the original charge sheet is not before court, the court cannot assess in this regard the full extent of the postponement itself, but the matter was also then placed on the 10th of March 2021. This was also then a date for further evidence, but the court was informed that the prosecution was not ready to proceed with the matter due to the pandemic itself, where it is COVID-related incident which was reported for the postponement in this regard. On the 6th of September 2021, the matter was set down for further evidence in this regard, and then it was postponed for 6, 7, 8, 9 of December. In this, subsequently, the court was also informed that we cannot proceed with the matter due to COVID-related incidents, also with regards to the defense attorneys in this regard then as well, that we could not proceed in this regard. Advocate holders have fully addressed the court, and the court have granted the postponement in this regard then as well. So the court also found that there was a delay which was caused, which was acceptable to the court with regards to not being unreasonable due to the pandemic, as well due to the aspect of illnesses which was suffered by both parties in this regard. On the 7th of April 2021, the matter was set down for purposes of further evidence. And on this particular day, we have then proceeded with one witness, and after that witness, General Zulu needed to give evidence in this regard. We could not proceed with the matter due to the extent. The court will just correct the date. It is the 7th of April 2022 in this regard, and not 2021. On this particular date, the court was informed that General Zulu is not available before the court. Annexure 1 indicate that a medical condition prevented her from giving evidence. In terms of Annexure 2, which has been presented today, after the consultation which the state has had with the witness, that General Zulu is still not before court due to a medical condition. The court will come back to this issue concerning the medical condition and what have transpired, which was placed before the court on the roll itself. Previously, the court have requested whether there was any notice given to the state that if the state is unable to proceed with the matter in terms of 3D of Act 51 of 1977, which is Section 342A in this regard, that notice must be given specifically where the accused have pleaded. This is to eliminate all aspects related to prejudice suffered by any party in this regard. In this regard, the court must assess the prejudice which needs to be suffered by the state in this regard, because they still have not closed their case and they need to call a witness to give evidence in this regard then as well. I have fully taken into consideration the judgments which the court was referred by advocate holders with regards to the delay, as well as the duration, as well as to see that goes to the extent that justice must be seen to be done in this regard, and also to the extent of the prejudice that is to be suffered. Now, it goes without question to say that the state is the party that would suffer prejudice in this regard, because they could not comply in calling all their witnesses timelessly. As Ms. Hart have indicated, that it is in the interest of justice for the court to listen to all the evidence before the court can make a ruling in this regard. Now, the state have then further indicated that it is indicated that the witness evidence could be seen in light of the interest of justice to be important to the defense and the state. Without that evidence, the court will not be in a position to conclude the case to the full extent of all the evidence that needed to be placed before the court to come to a just conclusion. Now, further to this regard, the court is also satisfied, as I've indicated, that the provisions of Section 342A is applicable. Now, when the court looked at the provisions of 342A, the court also come to the conclusion that the court have to take into consideration A, the court may then refuse the postponement for further as requested by the state in this regard, and the most important would be in terms of D, where the state have become unable to proceed. Now, as I've indicated, I will get back to the extent to the factors in terms of the medical note which was being given to the court. The court is also familiar with the ruling which the court have made, that the mere production of a medical note will not satisfy the court with regards to granting a postponement due to the delay which was caused. Each and every time which is material that a witness needs to be before court to give evidence, then it appears to the court that the witness is not available due to ill health in a medical condition. Now, there's also to an extent that on the 7th it was indicated to the court that the witness is suffering from chest pains as well in this regard, which I have duly taken into account. Now, when one looks at the copy which was given to the court previously in this regard, it will indicate a medical history and more particulars. However, the original medical certificate which the court has received today is only indicative of a medical condition. But be that as it may, the court finds as follows. As a fact, the state have placed before the court on record that there was an arrangement with the witness to be present today. They have consulted. They were ready to proceed with further evidence in calling the witness to testify before the court, to have the matter concluded today. The witness have not indicated to them any medical conditions, any aspect that would have prevented her for being here today to testify against the accused in this matter. Only upon realizing it due to the court start prior 9 o'clock, it was indicated that there was an arrangement that the witness would have been collected by Mr. Baba at the gate to be brought in today for purposes of further evidence in this regard. And instead of finding the witness, EFF then found an extra 2 in this regard, which is then indicated that there is another medical condition that the witness cannot be before court. With regards then to the delay, the court is well aware that the matter emanated from 2019 up until today. It is a mere fact that it is an assault common case. The court have listened to the complainant's evidence, the police officers who have testified also with regards to the control and access at the gate itself, and the evidence of General Zulu. At this stage will be speculative of what stance she will take in favor of the defense case or the state's case in this regard. However, the court finds that the mere production of this sick note as Annexure 2A, although it is a fact that the witness have indicated, but the court finds it very suspicious that the witness, and that there is no more reason with regards to her availability and what is this medical condition to prevent her from testifying in this regard, as indicated previously. The court finds that the 2 accused before court has been prejudiced in the completion of the trial. This trial should come to conclusion, and the court is refusing any further postponement in this regard. Thank you.
As the court pleases, Your Worship, in line with the court's ruling, Your Worship, this is the state's last witness. However, I have no option, Your Worship, but to close my case, Your Worship. As applying for remand, it may be interpreted that I am challenging the court's ruling, Your Worship. So, in line with the court's ruling now, I am then closing my case, Your Worship.
Beg your pardon?
In line with the court's ruling, Your Worship, I am then closing my case, Your Worship.
Thank you. Advocate Otis? At this stage, I believe Mr. Malema and Mr. Ndlozi may be seated.
Your Worship, previously I had indicated to my learned friend that I'd be in a position to argue the Section 174 application orally. We were also under the impression that the General Zulu was testifying, so we hadn't fully prepared on the 174. I could possibly address your Worship, but there are 3 hindrances in this regard, Your Worship. The first being that we don't have a complete record. My learned friend is also missing one portion of the record. The second being, Your Worship, that we believe that it would be in the interest of justice if we handed up heads of argument from both sides. We have, in principle, subject, of course, to Your Worship's approval, agreed to dates. And the third, Your Worship, is that both of the accused came back from Mpumalanga because of the tragic loss of their member of their party, the former Secretary General's daughter, Hilary Gardy. So they returned, and there's the burial tomorrow. So they're keen to get back there if it's with Your Worship's permission, because they want to sympathize with the family and assist in the tragic loss. So subject to Your Worship's approval, the request would be, Your Worship, that we file heads of argument within a week. That's by next Friday, the 13th of May 2022. The state to then file their heads of argument, Your Worship, by Friday, the 20th of May 2022. And then, subject to Your Worship's availability, we could have the next appearance on the 26th. It's a Thursday, Worship, 26th of May 2022, where either Your Worship can give a ruling or ask further questions if Your Worship wants further submissions in oral argument. That we will be in a position to file the heads in accordance with that time frame, Your Worship. And I say it's obviously subject to Your Worship's approval. And what we would also do then, Your Worship, is we would agree on a record that would be handed to Your Worship to follow the argument, because we have we've got the same page references, but then we'll just put it together, make sure that Your Worship's record is 100% in accordance with that which we refer to as well. A transcript has been running, Your Worship, and it is available. We're just missing one section, and my learned friend and I are missing one section, but other than that, everything else is available. She has the one section that we need, and there's just one section still outstanding, which I do believe we'll find timelessly.
What's that?
Your Worship, I have no objection, Your Worship, with regards to the dates that my learned colleague has said, Your Worship, for the heads, 13 May and 20, Your Worship. We are, however, in the hands of the court with regards to the 26th of May for the matter to proceed further, Your Worship. The date suits myself and my colleague. We are in the hands of the court with regards to the date if it's suitable, Your Worship.
I'm not sure. I don't believe the date of the 26th would suit. It's too close to end of the month. I have other requirements to do, and I believe my colleague will be on leave as well, if I'm not mistaken. So I'm not too sure, but close to the month, the last week of the month is not feasible. It can rather be the first week of the month itself.
The court can maybe then more or less suggest just a date, Your Worship, so that we can look from there.
Bishop, the first Friday of June is the 3rd of June.
Yes, if the 3rd of June suits
I
the
could make
parties.
arrangements to be here, Your Worship.
In order with me, Your Worship, 3rd of June.
So there's no objection with regards to the request. I was also addressed with regards to some incomplete record. Can I just get clarity with regards to such?
Yes, Your Worship. We are both missing the re-examination of Colonel Fenter by my learned friend. Both of our records don't have that. I can give Your Worship the date.
The record which was supplied to myself by the state itself, where I believe the full, I think I also do not have the re-examination of Colonel Fenter.
Your Worship,
as
my
well.
colleague and I just went
But
through
I
the
also
record.
do not have the evidence of both officials from the
Which?
police who have testified specifically with regards to the investigating officer, as well as the forensic person who have testified concerning the video. That is the evidence which I also do not have on the record. However, it will not affect the court. The court have full notes concerning such evidence. But if the state or the defense have such copy specifically on electronic form, that copy also be sent to the court itself.
We do have it, Your Worship.
And I've also now gone through the file itself. I am going to take possession of the exhibits today, but I do not have the video.
Yes, Your Worship. It was placed on record, and I found it, Your Worship, where it was said that it would be put in the custody of Mr. Baba.
Yes.
And
Today
then-
I've placed it on record that I have not verified whether everything is here except that the video or the USB stick,
Yes.
which I've now been given by the state in this regard, is then also been in my possession as well. The court will work through the said file with regards to all the exhibits and will make then a confirmation. If anything is missing, I will contact then the state in this regard to inform what is missing, but I believe everything is in order as per the index of the exhibits and as well as the video is before court.
And then I don't believe that Your Worship has the evidence of Staff Sergeant Mapisa.
Yes, I do.
I have it. Does Your Worship
Yes,
have it?
I do. It was forwarded to the court by way of an electronic copy by the clerk of the court in this
Yeah, we
regard,
don't-
so
we
I am in
don't-
possession.
We don't have that, but we will secure that from our learned.
Yes, I believe it is
Yes.
already available.
Yes.
If the parties do not have, the court is in possession of such, and the court can make it also available if requested to do so.
Thank you, Your Worship.
Anything else?
Your Worship, just with regards to the record that's missing from my colleague for the 13th of October, what I've agreed on is just to listen to the record to make sure that it is on and that the missing part, it is on the CD, Your Worship, and then I will then make it available, Your Worship, to my
everybody.
colleague.
Thank
Yes,
you.
Your Worship.
Can I just get clarity? This is with regards to only in the form of a CD.
Your Worship, we first have to see if, I've spoken to the stenographer, Your Worship. We have to listen to it, Your Worship, because we don't have the full record. That is the last part of my re-examination.
Yes.
Just have to listen that it is
the
recorded, Your
record.
Worship, and then we will then take it further for transcripts, Your Worship, to the appeal clerk, Your Worship. But we will just listen shortly, Your Worship, to see that it is available.
Then also with regards to the original charge sheet, because that will cause problems.
Yes,
How
Your
do the state request the court to conclude the matter on a duplicate charge sheet? And up until today, from the previous postponement, I have already indicated that I cannot consider this as a duplicate charge sheet. It is merely a copy of the court book made by any party, and it may have been tampered with, it may have been changed. The court cannot confirm because it is not certified by the clerk of the court that this is a duplicate. Why have this not been done?
Your Worship, we're still searching, Your Worship, for the charge sheet, Your Worship. That is why there is no certification as yet, Your Worship, because we were still searching for it, Your Worship. So on the last occasion, if we do not find it in by the 3rd of June, Your Worship, I will then inform my colleague and I'll also inform the court, Your Worship. And I will then also inform the court manager, Your Worship, so that we, and the supervisor, senior, Your Worship, in order to make the necessary arrangements, Your Worship, for everything to be certified, Your Worship. We are still looking for the original charge.
The court will just order with regards to the missing charge sheet. And the court do not want any further delays or any further excuses with regards to such. The original charge sheet is not before court. This should have been done to expedite the matter so that the court can have an official document before the court for purposes of postponing or to deal with the matter itself in this regard. So the charge sheet, the original charge sheet, is still missing today, and it needed to be before court today. In this event, the court have already voiced that this is just merely a copy which is not certified. The certified copy should have been made available today. So the court will now order that the original charge sheet should be found before the next appearance, and in the event that it is not found, that a certified copy of the original done by the clerk of the court should be placed before the court. The court is not accepting any further delays or any further copies which is not been certified by the clerk of the court. With regards to the said copy of this charge sheet, the court will also leave this copy in the possession of the state to compile a proper record in this regard then as well. Then I believe the date will be the 6th or the 3rd of June. I have noticed that the dates which was given to me, is those dates also in order?
Yes, Your Worship.
The dates will be then the 3rd of May and the 20th of May. The 13th of May will be the submissions of the defense heads of argument.
Yes, Your Worship.
And then on the 20th of May, the state.
Yes, indeed, Your Worship.
I believe then, I do not want to place it on the record, but I believe Mr. Baba have my email address. The court will allow the email address to be shared with Mr. Houders in this regard, only for official use in this regard, so that heads of arguments can be timelessly sent to the court in this regard. I would then expect the heads of arguments of Mr. Houders on the 13th of May 2020. If I do not receive heads of arguments on the 13th of May, it will affect the outcome of the 3rd of June in this regard for preparation. The court needs sufficient time also to deal with the aspects which both parties will have to raise. Same applies to the state. On the 20th of May, the court is expecting the heads of arguments. So the latest will be the court will then also grant time until the 30th day of May. If the parties have received each other's heads of arguments and they want to further comment, because I believe that will also eliminate all other aspects which the court on the 3rd may come and put other questions to the parties to raise certain issues. Upon receiving also the heads of arguments, and if there's anything, the court will also in due course raise any questions which the court feels that it needs to be addressed by the parties in this regard to eliminate all other further delays in the matter for the 3rd, so that the court can only give judgment on the 3rd of June in this regard, if it is acceptable to the parties. And after the 30th of May, the court will not accept any further responses from the defense or the state in this regard, because then the court will come to a conclusion for judgment for the 3rd of June. Is that acceptable to the state?
Indeed, so, Your Worship, it is
Mr. Holders?
acceptable.
Yes, Your Worship.
Thank you.
Thank you.
The court will then place on record the following proceedings will be applicable to have the matter concluded, that the state will submit sets of arguments on the on the 13th of May 2022. The court will just rephrase it. On the 13th of May 2022, the defense will submit heads of arguments to the state as well as to the court on this date. Now, heads of arguments is to receive later than the 13th of May 2022 by the defense. Same applies to the state to submit heads of arguments on the 20th day of May 2022 to the defense as well as to the court in this regard. The court then will allow until the 30th day of May for both parties to give any further comments on their respectful heads of arguments. Also, before the 30th day of May, if there's any aspect which arises which the court needs to further clarification from the parties, the court will also, as per email, inform the parties of such. All heads of arguments may be submitted by way of email in this regard. The court will accept it to be served on the court by way of email in this regard. Mr. Malema and Mr. Ndlozi, you may stand. In this regard, the court will then be fully in a position to not cause further delays in your matter. The case is then being postponed to the 3rd of June 2022, court number 13, for your application to be considered in terms of Section 174 of Act 51 of 1977. Both accused, you are currently on warning and want to appear at 8:30. If you fail to be at court or to remain in attendance until you are excused by the court, will lead the court to issue warrant for your arrest. You understand?
Yes.
You are then excused. In the interim, you may be seated. Court book. I am currently sitting in the conference room. May it be just brought for me to the conference room. Thank you. Court adjourned.
Thank you.